This is Ben Meiselas, and you're watching the Legal Roundup. We have Michael Popok here of the firm Zuppano, Patricius, and Popok. How are you?
I'm doing great, Ben. How are you today?
Good. By popular demand, last week's episode was smashing success, so we want to hit this week's key critical legal issues for everybody watching, and let's go do it.
Let's do it.
So the first issue, the first case I want to address, we teased this case at the end of last week's episode, and now it has become a reality. There actually has been a lawsuit filed. This is the liability of Fox News for calling the coronavirus a quote-unquote hoax and having their news reporters incessantly say this was all fake news and nobody should be worried about it. A Kings County Superior Court in Washington lawsuit was filed by a consumer watchdog group out there. The consumer watchdog group cites Washington state consumer protection statutes and claims that this is a violation of consumer laws. According to the watchdog group, they say we're not here to chill free speech. However, this caused significant danger. In fact, one of the members of this group claimed to have contracted COVID by relying on the false advice of Fox News. So, Michael, tell us about this case, and is there a case here?
Yeah, I think there is. And what you just mentioned last, which is that one of the members of the watchdog group actually contracted COVID, I think gives them their standing to be able to argue this in court. I looked through the lawsuit. I thought it was well pled. They have an interesting additional count that is sort of unique to Washington state, although New York has a similar tort. It's the tort of outrage. And that is a tort they're relying on in addition to consumer protection. New York has a tort called the prima facie tort, which this would also fall under. And that's a catch-all. When somebody does something bad to you and has caused you damage, it's probably a tort. And that's what they're relying on here. Look, I think Fox probably has finally crossed the line here. When the Sean Hannitys of the world in February take the position that there's nothing to see here, that this is a minor flu-like episode that the Democrats are using to their advantage, and all of their followers and their watchers follow his lead as they do everything else, and don't socially distance themselves, don't quarantine, or try some crazy cure that they're also promoting hand in glove with this. That's not tested, not approved by the FDA, which has also probably led to deaths and injury. Somebody's got to be held responsible. They've got a broadcasting license. They're regulated by the federal government. Free speech has limits, as the U.S. Constitution and Supreme Court has said. So I think this lawsuit is going to get well past the motion to dismiss. I think they've got a case here.
The Fox News General Counsel says this lawsuit is wrong on the facts and frivolous. Is there any concern, though, and you just referenced it, that we could be chilling free speech if this lawsuit prevails, and would we be opening up a Pandora's box here?
Yeah, I get the argument. I mean, the number of things we're going to talk about on this episode are going to be the intersection between the pandemic and public health and lawsuits related to it, and some amendment or constitutional right, whether it's the Second Amendment we'll talk about later with the NRA, or it's the freedom of religion that we'll talk about with churches staying open during the pandemic. But here, I think that it's going to be up ultimately to the Washington Supreme Court, but I think the U.S. Supreme Court, to decide, is this a case where you can't yell fire in a movie theater? Or is this a case where we could allow broadcasters really to play down a national health pandemic? I mean, let's use another example. Suppose Fox News during World War II told the United States citizenry, don't worry about the Germans or the Japanese. They're our friends, not our enemies. And don't do anything to protect yourself during the war. I think a court would find that there are limits to what you can say in the media under the First Amendment. And we're going to find out with this lawsuit, because this lawsuit is not going away, and there's going to be others filed, copycat suits that are going to be filed in its wake.
So Fox News probably has some insurance to deal with these issues. And going to the next issue, which is insurance. We all rely on it. Businesses thought that they had loss of business disruption insurance, and now they're filing as they're tendering claims that their loss of business or their business disruption insurance is not covering anything at all relating to this pandemic, because slipped into their policy was a anti-pandemic rider, which basically says you can't make this claim if it relates to a pandemic or virus. This arose out of the SARS epidemic, and insurance companies reacted by sliding these antivirus, anti-pandemic clauses into the riders. So when you have insurance, these are exclusions purportedly saying you can't make business disruption claims if you have a virus or pandemic related disruption. Businesses have filed lawsuits challenging the validity of this, citing the fact that there are state orders and local orders, and that's why they're shutting down as a result of these orders, which close their business and not the pandemic. Will the businesses succeed in their class actions against the insurance company, or will the insurance companies relying on these exclusions prevail?
I think the insurance companies have a tough road to hoe here. I'll give you a number of reasons. I agree with you that in these, what we call contracts of adhesion, which are unilateral contracts that you have to enter into if you want to get insurance. There's no one on the face of this earth that's ever been able to take a pen and eliminate or negotiate a term with an insurance company to get insurance coverage. And so, as you said, slipped into the boilerplate and the fine print. Post-SARS, insurance companies in business interruption settings slipped in a virus is going to be accepted from insurance coverage. The problem with that is what you just noted. It's not the virus. It's not that the owner or the employees of the company have come down with COVID-19. It's that we are in a national shutdown, a force majeure or act of God or government, where the company can't operate or will be violating federal, state, or local law, subject to criminal prosecution and fines in certain circumstances. So I think that when these contracts are ultimately reviewed by courts, which is where this is going to end up, courts will hopefully side with the consumer and find that under the interpretation that the insurance companies are taking, it's just not reasonable. I also thought it was interesting that the U.S. Congress has attempted to, through friendly measures, attempted to get major insurance companies to cover, under business interruption insurance, the pandemic losses. And 4 major insurance companies have all basically thumbed their nose at Congress and said, we're not doing it. So states have had to step forward. New York and 2 other states, Massachusetts being among them, and New Jersey, currently have bills pending in which the local government, the state government, is going to force the insurance company, in return for being able to do business in that state, to cover pandemic-related loss under the business interruption insurance, despite the exemption. So either it's going to be by state legislature or congressional action, or it's going to be courts taking the insurance companies to task, but I think they're going to ultimately be on the losing end. The problem is it's a long time away, and the businesses need the money now.
And it should be no surprise, although a man who likes to go out there and talk about the economy, Warren Buffett, whose wealth was primarily built on insurance companies and keeping the money of insurance companies to later invest across all of his lines, has remained notably silent. And I believe he's remained notably silent because anything he does or say can and will be used against him in a court of law. So we have not been hearing from Warren Buffett on this economic crisis.
Yeah, that's a very good observation. I'm sure he's got a part ownership in one of the 4 major insurance companies that basically said no to the U.S. Congress.
Moving on to Mike Francesa. Mike Francesa, for those who don't know, at WFAN, sportscaster, if you want to call that, announcer, afternoon drive-by speaker, whatever you call Mike Francesa. He took to Twitter, or someone took to Twitter, basically posting Mike Francesa's videos. They created a fan account, Fan House, which posted Mike Francesa's rants. In this particular rant, Mike Francesa talked about his disdain and disappointment and how Trump has handled the pandemic. Francesa's parent company, Entercom, since sent a letter to this account, Funhouse, that has been posting Francesa's videos over time, basically as a cease and desist, saying, you are taking our copyrighted footage, you are putting it on your Twitter account, you have absolutely no right to do it. Take it down, we're going to sue. The Fan House did, in fact, take it down, basically said, your success recently has been based on us. We'll unfollow you. We were making you cool to begin with. But was Francesca and Entercom ultimately right? Were they the copyright holders, and could they in fact tell this Twitter account, this anonymous Twitter account, that they should in fact take down the content?
Well, first I've got to do our East Coast, West Coast thing. There's a big advantage to you and I being on different coasts. So he pronounces his last name Francesa. So for our viewers and listeners, I got to make sure I hold up my New York street cred that I know how to pronounce Mike Francesa's name. I've listened to him for a long time. But look, under the copyright laws that we're going to talk about later on in the TikTok matter as well, the question is always going to turn on what is fair use, what can somebody else use, and whether it matters whether they're making money on it or not. And I think ultimately it really doesn't matter. If somebody is using your copyrighted material, even if it's ultimately to your benefit, because let's be honest, most people outside of the tri-state area in New York, they don't know Mike Francesa or how to pronounce his name, right? So the fact that he gets 20 or 30 million views because Fan House or Back After This sites on Twitter and YouTube take clips of his, sometimes in a negative light, sometimes it's really to make fun of him, but it's driving traffic to his brand that he himself is not able to generate himself. I mean, there is a line of thought that he should be happy that somebody is taking and reposting his clips because it's a wider audience he never would be exposed to. But if you're looking at it from a purely copyright infringement standpoint, I think he's got decent grounds on copyright infringement. Whether he filed the copyright, whether he announced on his show that this is by copyright and all unauthorized uses aren't permitted, it doesn't matter. It's his original work, and somebody else is trying to take it and use it to promote their business model. Even if they're not making any money on it, and let's be frank, these sites are making money on it, or they'd like to make money on it because they've got a business model of their own with advertisers and other sponsors that link to their site. So I think at the end of the day, he has a good argument. If he wants to make it, I don't think from a brand business standpoint he should be making the argument. But if he really wants to go to court over it, over the cease and desist letters, he probably would win.
And I think that a lot of brands and businesses are dealing with that balance right now, in terms of cracking down on Twitter sites and Facebook sites and YouTube sites that are promoting the brand. I mean, how many fan sites of the NBA or other sports are posting these clips, short clips, and making a whole business model out of posting, what otherwise would be copyrighted clips of professional sports, and people cutting and pasting, clips of CNN and clips of Fox News. And, on the one hand, these could in fact be, infringements. On the other hand, you have the businesses saying this is actually helping our brand. Is there a concern though, Mike, from the businesses' perspectives when you don't enforce your copyright, when you just let people go and post it, for you to then go back and say, hey, now you're damaging me by not enforcing it while it's ripe?
Yeah, I agree with you. In the Francesa matter, this has been going on for a long, long time. And the question the court's going to have is, did he sleep on his rights? Did he allow, by what we call in the law, acquiescence? Did he allow his copyright to fall into the public domain? Does he still own it? My gut is, for the past postings, he's not going to be able to do anything about it. But I don't think he's forever barred from enforcing his copyright just because he's been lax in the past. But again, this is a balancing act. This reminds me of the file sharing and music sharing sites from 5 and 10 years ago that were all the rage. You could get free music and downloads. Look, the artists were happy because their music was getting distributed, but then they were sad because they weren't getting any royalties. And finally, they pushed all those file sharing and music sharing businesses out of business.
And speaking of file sharing websites, the modern incantation manifestation of file sharing and the new war between the music industry and the next large enterprise that has found creative ways to integrate music without getting the appropriate publishing licenses, the music industry potentially versus TikTok and its parent company ByteDance in China. One of the things that I didn't realize, until this week when I read some of the literature, is that TikTok and ByteDance, its parent company, really for about 50% of the songs that are on TikTok and potentially more don't have the appropriate licenses whatsoever. And so the music industry, through this publishing entity that speaks for all of the various publishers, remember in the music industry, there's both the recording itself for the track and then the publishing for the songwriters. So here the songwriters, represented by the publisher, sent a letter basically to TikTok saying, you need to enter a deal with us and pay us so we can pay the writers, or else we're going to sue. Mike, what do you think about this lawsuit? Is the recording industry right? Are they going to dig in their heels in the way they did with Napster and some of these other file sharing services back then? Where do you see this headed?
Yeah, TikTok is a very, very unique attack by the publishing industry, and I'll tell you why. As you noted, the parent company and TikTok is probably the most popular music sharing, video sharing site presently, and maybe of all time. I read the stat today that it had, in February alone, 1 billion worldwide downloads, 100 million of them in the United States. But the problem that they're going to face is that they are Chinese owned. And so you've got the Treasury Secretary, Mnuchin, and Senator Marco Rubio, who have decided to come after TikTok and its parent company, claiming that its censorship policies and takedown policies in China, not allowing freedom of expression. One way to attack that here in the United States is to go after TikTok. And the fact that TikTok is perhaps and probably copyright infringing every time a user posts their version of Drake's new song with a dance included, that is likely a copyright infringement. But it's also odd because the artists themselves are on TikTok. Drake just dropped his own TikTok video. So, it's weird. Again, we're back to like the file sharing world. It is exposing the artist to a tremendous amount of, worldwide publicity and fan base. 1 billion downloads in the month of February can't all be wrong, right? But at the same time, it is copyright infringement. And what I also have researched, as you have, is that apparently only 3 or 4 major publishing houses have signed some sort of deal with TikTok. The vast majority are not covered by a license agreement. And this is why the National Music Publishing Association, the NMPA, has come out strongly trying to get the Treasury Secretary and the US Senate on their side, claiming that this is a Chinese company. The real question is, if it wasn't a Chinese company and it was a Canadian company or a US company, would everybody be up in arms about the copyright infringement?
Yeah, and I think in terms of jurisdiction, though, what we would have the power to is the moment the Chinese company reaches out through its long arm and does business and conducts business in the United States, and they have a headquarters, here in the United States, in addition to their main corporate headquarters in China. I mean, there is jurisdiction to sue them for doing business here, but ultimately there does present extraterritorial challenges in terms of collecting, enforcement, how, jurisdiction in terms of where the litigation would take place. And it's just harder to sue a foreign entity.
Yeah, I think the civil suits are going to be difficult. I mean, as I said, 100 million downloads in the US says there's jurisdiction. But the problem is collecting. That's where I think if this is going to go anywhere, it's going to be the federal government taking a stand and shutting down the site in the US because of its flagrant copyright infringement, if they want to go that far.
Moving on to the next topic, the ailing National Rifle Association, NRA, is now suing states. Sued New York this past week. Before that, it sued California, saying that you told us to shut down. You're claiming governments that wear non-essential services. Hey, there's something called the Second Amendment. There's nothing more essential, the NRA argues, than self-defense. And they're arguing we should not be classified as non-essential. If you're keeping cannabis stores open, if you're keeping grocery stores open, if you're keeping other things that you're deeming to be essential open, the Costco's open, people have a right, especially in times like this, to bear arms. Especially as governments could potentially be breaking down and people may need to protect themselves, so the argument goes. We're an essential service. Do you think the NRA has any legs to stand on here?
As you just mentioned, it's interesting what's being considered essential businesses in various places. In New York and in California and other places, liquor stores have been deemed essential, and their numbers are going through the roof. Now you turn to a constitutionally protected right, which is the Second Amendment. And the question is, and we talked about this in our last podcast, the question is, in a national health crisis, what are the constitutional limits of any of the constitutional amendments or Bill of Rights that a governor or federal government can infringe upon? And the limits are going to be established by lawsuits like this and by courts, in this case, the Northern District of New York, where the capital of New York, Albany, sits for the New York lawsuit. Look, I think this is something that the NRA felt they had to do. As you said, they are flailing and failing. They've had leadership issues. Oliver North stepped down as its president. They've had funding issues. They've had relevancy issues against the surge of gun control advocates and groups that have really come to the fore as the Democratic Party has gotten their act together in advance of the presidential election. So from their perspective, I don't think the NRA thought they had a choice. I think unless they're going to be completely irrelevant, I think they had to bring a suit to challenge the Second Amendment. And you know what? The optics of it, and declaring that the right to bear arms is an essential right that even governors can't trample on, they'll get that case past motion to dismiss. And it's an important issue. And it's one that you and I need to talk more about, because I'm not sure where I come down on it.
I agree with that, and I know I have mixed feelings. On the one hand, I believe in common sense gun reform. I believe in gun control, common sense. I don't think there should be ARs out on the street. I don't think there should be AK-47s out on the street. I believe people have the right to bear arms. I believe they should have the right to hunt. But as you said, as we're calling alcohol essential, as we're calling certain delivery service essential, if you do have a constitutional right, the Second Amendment says we have the right to bear arms. There's nothing more essential than something that's declared in the Constitution, as being essential. And the right to bear arms, our forefathers and founding fathers have found that is essential. So it's hard on the law to disagree with them. Now, in these pandemic crazy times, do I want to see potentially misinformed people based on the prior segment that was in Fox News, walking around with ARs and patrolling the streets, with artillery? Absolutely not. But do I think that here the NRA has a point? Absolutely. I do think they have a point here, and I think they're probably going to prevail. Moving to the final issue, and this is a disturbing one. It seems that in a time of crisis, there are so many people who come forward to do good, but there's also people who come forward and have these insidious agendas that they want to push. And so right out there, there's right out there in New York, there is a anti-gay minister, preacher, who has, under the pretext of helping deliver services to people in need, has imposed a very strict anti-gay agenda in hiring practices and who they're going to be servicing. And it raises a whole bunch of red flags. And you're closer to this issue, literally and figuratively, being right out there in New York than me. And so, maybe you can walk us through what's going on there and what you think should happen.
Yeah, you're talking about Franklin Graham, who's the son of, probably one of the most preeminent spiritual leaders for the United States, the minister and pastor to 7 or 8 presidents, Billy Graham. And when you and I had our podcast last week, I talked about in glowing terms, Samaritan's Purse, which is Franklin Graham's organization, setting up what amounts to a field hospital. And I'm even closer than you think. I'm 10 blocks from the field hospital on 95th Street in Central Park that was set up by Samaritan's Purse. And so I talked about it last week as a juxtaposition with Liberty University and its founder letting everybody go to class or forcing them to go to class. And I said, well, here's an example. One took leave of his senses, and Franklin Graham's doing something great. He's setting up a field hospital. And no sooner did I say that I found out that Franklin Graham and his organization is making a requirement, a litmus test for anyone who works in the field hospital, that they're straight. and that they declare on a form that they're not gay. First issue is, how is New York State giving them public land in Central Park with all of the anti-discrimination laws that exist in New York City and New York State to operate this field hospital, allowing a discriminatory organization? It would be like if an organization said, we're going to treat everybody but African Americans or Jews. It's crazy, but you're right. It is sad and disheartening that at a time where we should all be brought together, in a time of pandemic, that they just can't get out of the way of their own undermining agendas. Either don't operate.
It's clearly unlawful. It's clearly would be subject to civil liability, administrative fines. But the question is, right now, as services need to be delivered and courts are frankly closed where you wouldn't even be able to get that relief, are they going to be able to stay open? And are they going to be able to continue these discriminatory policies and who they're treating? Or might you think someone's going to step in?
I'm actually surprised that Governor Cuomo, who's been getting great compliments for being a very strong governor and holding daily conferences and press conferences, that he hasn't taken a stronger stand, or that Mayor de Blasio hasn't taken a stronger stand through his administration to shut down or to get them to change their policies. They don't have to operate the 90 beds in Central Park. Between the USS Comfort ship that showed up and apparently has 10 or 12 people on it, the entire ship. I'm not sure those extra 90 beds are really adding to the capacity in New York, and at what price to allow for the discriminatory delivery of services to the weak and sick and dying. I think New York is better than that. I think the U.S. is better than that, and we should say no thank you to that type of charity.
And I think, just as concluding remarks, what you just said probably sums up the entire conversation that we had today, which is at what price? And that is, during a pandemic, there are obviously sacrifices that are needed. We all need to shelter in place. We all need to follow and comply with government deadlines, government requirements. But at what price? Do we totally sacrifice and give up the Constitution of the United States of America? Do we forget about our anti-discriminatory practices? Do we turn a blind eye as people try to exploit the pandemic for their own, selfish and individual use? And that's something that you and I are going to continue and keep monitoring and holding people accountable. So thank you so much, Mike Popok, for joining us again. We look forward to talking with you next week, and look forward to your contributions to Meidas Touch.
All right, thank you. Thanks, Ben. See you next week.
Thank you.